Who? Yes, madam. Ready? 76 I am ready, madam. Yeah, opposite. Question of liability will not know. All the police is there. One day. Every person will go.
What do you want time?
Is it 30 minutes? Is it?
Okay, after tomorrow. The request of the for the
13 minutes?
yes, 13. They're seeking time on
Yes,
day after tomorrow.
Bernard, may I request Bernard, can it be called on Tuesday? My health Bernard knows I mentioned.
Tuesday.
Okay, Shantra.
Yes. Yes.
The injury case, they died, laws are not entitled. Beyond the latent statement of the apex court, they are entitled for opportunity.
Please pass on.
Incoming? 10% time. Now, what is that?
So, as per the judgment, even after the death of the injured claimant, claim petition does not abate and right to sue survives to his heirs and legal representatives. And so far,
Entitled for
No.
loss of estate. Therefore, compensation has to be granted. Applying the multiplier and taking the income and the adding future prospects. In this case, the disease was aged about 50 years. The man is wife. She has brought on record. And this court fulfills decision. Both has been overruled by the apex court.
let us see what is the material before the court below for assessing the compensation.
Here, okay.
Quantification is not made, my lord. If that is so, then it has to go back.
So let us see what is the material at least for this court to come to.
Only relying upon the judgment of the fulfilled decision of the court. The Kannamar's case, ALR 1990 Karnataka court made a They have discussed the judgment and dismissed it. Even this court fulfills and held. They are held for medical expenses and other expenses. But the tribunal member, in entirety has dismissed it. So, both the judgments of this turnabout court, Unified decisions has been overruled by the effect.
No. What about issue number 1?
Issue number 1 has been affirmed. Yes, affirmed.
Issues are not reframed.
There is no discussion, no evidence on record. Now, on what basis this court will arrive at a conclusion that this would be the compensation?
Since he is a dead,
For that, there should be some evidence, not for his what was his occupation, what was his earning.
yes, let evidence, he was doing agriculture and cooling work and milk finding work. The basis of that it could be arrived at before the court instead of remanding the matter.
Which year is the accident?
2010. 3/2/2010.
What was the age?
50 years. Ayush.
Yes.
Lord, the claim petition was presented by the injured claimant. Now, during the pendency of the Lord, he died. And LR Malord was brought on record by an order dated 21/9/2011. The wife of the Malord, the deceased, got herself examined as a PW1. Malord, they have not proved the nexus between the injury and the death. PM report may kindly be looked at. No PM report has been produced. Charge sheet exhibit P2 was under section.
When was the accident and when was the death?
The accident is 3/2/2010.
And he died on?
And the LRs were brought on record on 21/9/2011.
2010.
On
20?
what basis?
2010.
Is the date of death or?
That will die. But in the new act,
There is no proper material as to the date of death and cause of death. Exhibit P2 charge sheet is under section 279(338). IPC read with 134 of the MA.
Oh, you have not claimed the LRs have not claimed compensation for the death of the deceased. They are only continuing the proceedings which are instituted by the claimant. That is for the injuries sustained by him. What are the injuries sustained by him? What are the amounts that were spent? And you have to examine the doctor also. Or what are the exhibits marked in your behalf? No, question of death and the other things cannot be taken into consideration now.
No, I did not prove excess between injury and death.
No, not the
question cannot be done.
not the nexus, not the nexus. Issue is he has filed a OP for claim petition for the injuries sustained by him. Now, when the LRs are only continuing the proceedings which are instituted by him for the injuries or for the compensation for the injuries, it is not their case that because of the said injuries he has succumbed to the same and he died, and now the compensation has to be for the death of the deceased.
Not loss of dependency.
In any petition, amendment petition was filed.
Amended petition has been filed.
Where is that? Please take the record. No, there appears to be no other petition by you. It is only for the injuries. Now, to assess, now the issue was,
Petition has been filed. Comes to the amended petition.
where is that?
Unfortunately, they have not paid it. Of course, apex court has categorically states that in official area, they are not deficient, advocates are not deficient. It has to be construed liberally. It has to be construed liberally. Therefore, here which I am cited before the citation, in that case also same petition. Yes, there during pendency of the claim petition. After LRs are, you are looking at they have computed the compensation.
Well, see, definitely there would be a petition seeking compensation for the death. Otherwise, why would the court say that it has for a petition which is filed for the injuries has to be converted into that? Let's see the facts.
All the petitioner has relied on the accidentally question occurred due to the negligence on the part of the rider of the workers and the hearing. And in the said accident, the negligent petitioner absolutely nothing has been elicited with the response to flow. Accident was not occurred due to the rash and negligence act on the part of the rider of the ferry vehicle. Issue number 2. The present claim petition was filed by one Sri Nagaraj any compensation for the injuries sustained in the accident that had taken place on 3/2010. So on going through the record, so against the present claim, that claimant was reported to be dead. All his legal representative got on record. By order dated 21/9/2011, immediately the present claim petition filed by the civil Nagaraj for the personal injuries sustained by him, accident that had taken place on 3/2010. Now the crucial point before the court is that whether the legal representatives of the deceased are entitled for compensation for the personal injuries sustained by the deceased Nagaraj. In my view, certainly not in the light of the victim laid down by their lordship, the decision rendered in ILR 1990 Karnataka. Yes, going on, referring the judgment and before that, the injuries has been stated
Yes.
in the increase 8, not 3. Take increase 8. Claimant had and national against claimant caused the accident. Immediately was referred to government hospital. After first aid, he was referred to Nimau Hospital. And further, he was referred to Rajinikanth Hospital, Bangalore. Admitted as inpatient and treatment about 30 days. During this period, claimant also underwent an operation to his fracture. Further, he was referred to Victoria Hospital, Bangalore. And admitted as inpatient and took treatment about 20 days. And further, he was referred to St. John Medical College Hospital, Bangalore for more treatment. When he took treatment for 1 month, further he took treatment as outpatient in Karnataka Medical College Hospital. And he has spent 2 months for medical and other incidental charges. He further contended that he was able to help with private property. He was doing for agriculture work in the account from his earning 9,000 per month and maintaining his family. If you said the accident, the claimant is unable to deliver where to the accident. And he never stated what are the injuries has been. It's not discussed the injuries sustained by the disease. In fact, there is a paraplegia. Two discharge summaries has been produced. And medical bills also produced. Stated in claim petition. Two compression fracture with traumatic paraplegia. Posterior dislocation of left hip joint. Deep fracture of left side and other injuries.
No, there are 34 medical bills. That is exhibit P10. In respect of medical bills, unless and until you examine the person who has issued it, or some person from the hospital, those cannot be considered by the court. So on what basis this court can grant compensation to you is the
For the
question.
death of a person, loss of dependency, and this invention that's compensation has to be there. Of course, medical bills has not been disputed by the respondent.
Now, where do you get all that? Because court has not gone into that.
Yes, certainly, that's what a tribunal member has not gone into all those things.
If you want, we'll remand the matter.
I think remand is not a correct one. If court feels remand, in fact, Supreme Court itself has been granting the compensation in apex court. It's a federal exercise. Remanding the
Because before the Supreme Court, the court below has done the entire exercise, but granted a limited compensation. Then basing on the material, court has
It has
enhanced
been
it.
granted for injuries sustained by the claimant. Here, it has not granted any compensation.
Yes,
Yes. Lord, you have to kindly see the claim petition was presented by the injured Nagaraj. Then, my lord, the wife was brought on record as an LR. Now I'll take your lordship to the, my lord, the deposition of PW1. That will clean the issue. You have to kindly have, my lord, the deposition of PW1 examination in chief.
yes.
I am the claimant in the above case. My husband has filed this claim petition against the respondent seeking compensation due to the injury sustained by him in a motor vehicle accident. During the pendency of the above claim petition, my husband Nagaraju was dead, having a living behind me as his legal representative. Date is not coming. I submit that on 3/2/2010 at about 2 p.m. my husband was proceeding on the extreme end of the left side of the ring road by walk near Kesar Madu Cross, Katsandra, Tumkur. At that relevant point of time, one Hero Honda Splendor motorcycle number so and so being driven so and so in a rash and negligent manner without following the traffic rules came from the backside of my husband and dashed against my husband and caused the accident. Due to the said accident, my husband fell down on the road and sustained grievous injuries and fractures like L2, wedge compression, fracture and traumatic paraplegia and post-general dislocation of the left hip joint, ribs fracture of a left side and other injuries all over the body. And immediately after the accident, my husband was shifted to Government District General Hospital, Tumkur. After the first aid, my husband was shifted to Nimas, Bangalore. After necessary treatment, my husband was shifted to Rajiv Gandhi Hospital, Bangalore, and admitted as inpatient and took treatment for 20 days during
I've seen the evidence. What do you want to say?
But in the whole evidence, my lord, nothing has been, my lord, stated about the, my lord, the dependency. Now, my lord, they want that the court to be compute the compensation as if it's a case of death. In the entire evidence, my lord, no, my lord, whisper about, my lord, the dependency.
But if you look at the injuries, they are very grievous in nature.
Yes, I'll come to that, my lord. Even if that is so. But as I said, charge sheet was filed under my lord 279/338 IPC. If there was a death due to the, my lord, injuries caused, then there should have been a charge sheet under 304A. That is not there. Apart from that, PM report is not produced to show the cause of death. Death is there, but cause of death is not there. And you must kindly see what are the documents were not produced by the claimant. Wound certificate and 2 discharge summary. That's all. There is no pleading, no evidence as to the dependency, even if it has to be treated as a case of death and dependency. Cause of action for an injury dies along with the malodis thing. That your lordship is aware. Actio personalis mortem cum persona. At the most, yeah. So at the pardon?
That was dealt by the apex court in the said judgment, which is relying on.
Yeah.
And
Even
the court has held that they can maintain. Now here the issue is, here the only issue is, how does the court now will quantify the compensation? Not about the maintainability, and others are not in issue at all. And the tribunal and the order passed by the tribunal is bad. It has to be set aside. Now, remanding the matter, which is the accident is of the year 2010. What would be the purpose of it in remanding it in 2024?
It is for the claimants to, my lord, because in the absence of evidence, my lord, the court cannot presume.
At least the age is not in dispute. We will take the minimum. We will take the minimum wages.
I am very sorry, my lord. That would be overstepping. Because if a quantification is made by the tribunal, I have got a right of appeal. Now, my lord, the cause of death is not proved. Their entire case is, my lord, is for the injuries. Cause of action for injuries dies along with the, my lord, decision. And entire, my lord, deposition of the lady.
Yes.
Speak about, my lord, dependency at all. Therefore, my lord, in all the fitness, my lord, the matter has to go back, remanded. Let them lead evidence, my lord. Proper evidence. If they are entitled to for injury or for death, let them have it.
What evidence they can lead at this point of time?
They can't preclude my right of cross-examination. And issues has to be reframed. Issues are not properly framed in the light of monarchy. Therefore, on several grounds, the matter has to go back, as your lordship earlier observed. Let them lead evidence. If the cause of death is due to the injuries, then there is a court open to them is different.
What he is arguing, probably he don't know the judgment of the apex court. In fact, in the new act, same word has been used in the act itself. He need not claim and need not prove the nexus between injury and death. The 2019 act, there is a question of proving excess between injury and death. LRs are entitled for compensation. For that reason, since it is a 2010 accident, I remind I hesitate.
What is the age?
58.
He can examine a doctor in the light of the medical record available and can obtain an opinion of the doctor. In the absence of any evidence, there can't be presumptions.
Unfortunately, at this point of time, if the matter is remanded, what is the evidence they can adduce after even the doctor, none would be present now.
Not according,
Many
yes,
people might have left the world.
according to the medical record, he can give an opinion. It is open for the insurance company to malot the cross-examine the doctor. Then the dependency, suppose if it is a question of malot, they want the compensation to be computed as if it's a day skip and death dependency. There should be an evidence. Where is the evidence? If everything has to be presumed, then there is no end of it.
How many are the claimants? Considering the income as 4,500, will grant compensation. No, will apply Ramchandra Perkins. Oh, income. Agreed whether. That is also calculated. Union appeal fund whether payment agreed whether award passed. Agreed whether award passed. Uh, agreed by dismissal of the claim petition passed by the court below by the order dated 5th September 2012. The claim petition was filed seeking compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant. During the pendency of the claim petition, the claimant died and his wife was brought on record as LR. It is a case of the claimant that on 3/2/2010 at about 2 p.m., the claimant was proceeding on the extreme end of the left side of the road. They walk near Keshar Madu Cross. The relevant one Hero Honda Splendor being driven by its rider with high speed in a rash and negligent manner without following the traffic rules came from the backside of the claimant and dashed against the claimant. Because of the said accident, he has sustained grievous injuries. Give the record. injuries, N2 wedge compression fracture, a traumatic paraplegia, posterior dislocation of left hip joint, rib fracture of left side, and other injuries all over the body. And immediately after the incident, he was shifted to the government hospital. After first aid, he was shifted to Nimhan, Bangalore. Thereafter, he was shifted to Rajiv Gandhi Hospital and admitted as an inpatient and took treatment for about 20 days. And during that period, undergone operation for ribs and other parts. Thereafter, he was shifted to Victoria Hospital and took treatment as inpatient for 20 days. Later, he was referred to St. John Medical College, Bangalore for more treatment and took treatment for 1 month. Further, for better treatment, he was referred to the St. John Medical College and taken treatment as outpatient. According to the wife of the claimant, he has spent lot of amounts because of the injuries sustained by him. And because of the said injuries, he always, even after the treatment, he continuously requires the assistance of the family and has become permanently disabled. The claimant, the husband of the appellant herein died on. Accident has taken place on 3/2/2010 and he has died on 27/6/2010. The claim petition is dismissed by the court relying on the judgment of this court in case of Kannamma versus Deputy General Manager, ILR 1990 Karnataka, page 4300, that the LRs cannot maintain the petition filed for the compensation. Then counsel appearing for the claimant submits that the judgment of the tribunal, the award passed to the tribunal has to be set aside. It is submitted that the legal representatives can maintain the application. It has relied on the judgment of the apex court in case of Oriental Insurance Company Limited versus Kehlon alias Jasmail Singh Kehlon through LRs, reported in AR Online 2021 SC 511. Land Council submits that the Honorable Apex Court in the above referred judgment that the claim for personal injuries may not survive after the death of the injured, unrelated to accident or injuries, but claims for loss of estate is available and could be pursued by the legal representative of deceased in appeal. He submits that the apex court, though the tribunal has on technicality rejected the claim, and when the High Court has granted a very meager amount, the Honorable Apex Court in the said judgment has granted the compensation of an amount of rupees 28,42,175. Learned counsel appearing for the insurance company submits that before the court no evidence was adduced by the claimants about the what the nexus between the injuries and the death of the deceased. The postmortem PME is not filed before the court. He submits that unless and until the doctor is examined and the relevant documents are filed before the court, proving the nexus and the reason for the said death, the claimants are not entitled for any compensation. He further submits that there is no evidence on record either on the income of the deceased or on any amounts spent towards the treatment. It is submitted that at best the matter could be remanded to the court below, and the insurance company will get an opportunity to cross-examine the doctor. Anything else? You have muted your audio.
Dependency is also not spoken to.
He submits that he has drawn the attention of the court
Even
to
otherwise.
the evidence of PW1 and submits that in the said evidence, nothing has been stated about the dependency. The accident has taken place in the year 2010. As per as per the case of the claimant and as per the medical reports, the age of the deceased is 50 years. Initially, the claim petition is filed seeking compensation for the injuries. That is on 3/2/2010, and he died on 27/6/2010. PW1 in her evidence has stated about the injuries and the hospitals in which he was examined. About 3 to 4 hospitals, the claimant, the husband of the appellant herein was shifted. And along with the claim petition, on their behalf, exhibits P1 to P11 were marked. P6 is a wound certificate. P7 is a 2 discharge summaries. P9 is the prescription, and P10 is 44 medical bills. P11, 3 X-rays. And as per the evidence, he has sustained three grievous injuries. That is L2 wedge compression fracture, a traumatic paraplegia, posterior dislocation of left hip joint, hip fracture of left side. As far as the medical expenses that were spent by the claimants are concerned, there is no evidence is let in, and only the prescriptions were marked. This court cannot, the bills were marked. This court cannot grant any amount. But when it is the submission of the learned counsel with the respondent that the appeal has to be remanded. In the considered opinion of this court, in an accident which is of the year 2010, remanding the matter at this point of time, after almost 13 years, no purpose would be served, and even examining the doctors who are treated and all is practically not possible. However, this court is of the view that basing on the available material on record, the case of the petitioner can be considered. Then once in the light of the judgment of the apex court, when the LRs can maintain the application, the judgment of the tribunal has to be set aside on that ground. Then coming to the compensation, as far as the medical bills are concerned, as basing on the material on record, this court cannot grant any amount. Then coming to the loss of estate and other under the other heads, in Ramchandra Pa's case, the Honorable Apex Court, without there being any evidence where the accident in the said judgment is also of the relevant year, as in this case, has taken 4,500 as a income of an agricultural labor. Hence, this court is also inclined to consider the same as for the income as 4,500. And 1,100, as he is 50 years old, 25% future prospects would come to 1,125. That is 5,625. And if towards the personal expenses, 1/3 is deducted, that is 1,875. It comes to 3,750. His contribution would come to 3,750 into 12 into 13 would come to 5,85,000. 44,000 towards funeral expenses, loss of the consortium, and 33,000 towards funeral expenses, and 10,000 towards legal expenses would come to 6,72,000. Though learned counsel for the respondent has argued technically on the aspect of losing the right of appeal and remanding the matter, considering the judgment of the apex court in Oriental Insurance Company Limited versus Talon alias Refer Supra, and wherein the apex court has discussed at length about the beneficial and beneficial nature of the legislation, and particularly beneficial nature of the legislation, where the court has observed that the claimant need not prove the nexus between the accident and the injuries. This court is inclined to allow the appeal by granting compensation of an amount of rupees 6,72,000 at interest at 6%. The insurance company is liable to pay the same. As the court below has already given a finding on issue number 1 that the accident has happened because of the rash and negligence of the driver of the offending vehicle. Who appears for the respondent? Item 15.
I appear for the respondent.
Yes. It's a claimant's appeal.
Yes.
Oh. It's a case of injuries. Injury. Rejected. Let us. Page number. No, let us read. Let us read. From issue number 1, para number 9. Yes, I've seen page number 7. No, not about the delay, not about the delay in the complaint. No, when is the accident? It is on 15 to 2011. And as per the wound certificate which is produced by you, you have sustained 3 fracture injuries. And after sustaining 3 fracture injuries from 15 to 2011 till 18 to 2011, you were sitting at home. It's not the question of delay. With a fracture, how can somebody sit at home? No, you will go to some hospital, fracture injury, is it, can you bear the pain for 3 days? No, in villages also they'll go to, then there should be, no. You must have said so, 1 minute. You must have said so, you must have, please listen to the court. Okay, let us assume that what all you say is correct. They should have said so in the evidence that so and so happened and we have taken some local treatment and as nothing is working out, then we have gone to the doctor. No, you didn't say so. And coupled with that, the complaint which you have given after 7 days, also that that has not inspired the confidence in the mind of the court. You say you went to the government hospital. For that, there is no document filed before the court. That is later on 18. Nothing on record. Come. There's an appeal filed by the claimant. Huh? Come. No, I didn't get you. There's an appeal filed by the claimant. Agreed with award passed in MAC number 317 of 2011, dated September 2012. The claim petition is filed in compensation of an amount of rupees. How much you claim? Huh? Claiming compensation of 2 lakh. The court below has dismissed the claim petition. While dismissing the same, the court has observed that on perusal of the documents exhibit P1, FIR, P2 charge sheet, it shows that the minor petitioner met with an accident and sustained injuries. And on perusal of the wound certificate and medical bill, it shows that they have produced wound certificate as per Exhibit P5 and 23 medical bills as per Exhibit P7, and those bills are pertaining to Sri Lakshmi Ranganatha Medical Sira. On perusal of the medical bills, which are from 15 to 2011, 16 to 2011, 19 to 2011, 20 to 2011, 10 3 2011, 20th 3 2011, 8 4 2011, 13 4 2011, 21 4 2011, 18 5 2011, up to the month of March 2012. The court observed that they are suspicious in nature because, as per the version of the guardian, the minor was taken to the government hospital and then to district hospital, Tumkur, where he has taken treatment for 1 month as an inpatient. But there is no document to that effect. Even the wound certificate itself shows doubt regarding the treatment taken by the petitioner at the government hospital, Sira. And moreover, the petitioner also examined the doctor as PW2, who is not the doctor treated the petitioner after the accident. It is also observed by the court that he went to the hospital on 18 to 2011. He went to the hospital on 15 to 2011, but the wound certificate shows the date that is as 18 to 2011. When he has met with an accident on 15 to 2011, the court has observed that why he has not taken till 18 to 2011, there is no whisper in the entire evidence. That too, when the 3 injuries are fracture injuries and 3 injuries are simple in nature. The court observed that no person will sit for 3 days without taking treatment for the injuries. Neither the father of the guardian nor the doctor has not spoken about the same.
Not treated there. Doctor is not treated.
That's what that I recorded. When the government doctor was examined, he has not produced, if at all, he was treated in the government hospital, either MLC or any document regarding the treatment given to the minor. Apart from that, apart from the treatment, the court has also observed that according to the claimant, accident has taken place at about 10:30 a.m. Immediately on the same day, he has taken on bike to the government hospital. Since no one is there to look after the injured, the complainant filed the complaint on 22 to 2011. There is a delay of 7 days. The court observed that if the version of the complaint is believed to be true, then why he has not produced the documents of his treatment on 15 to 2011 is also not known. Considering all these circumstances, the court has disbelieved the version of the claimant and dismissed the petition. Then counsel appearing for the claimant submits that as their rustic villages and as such there is a delay in approaching the police as well as taking the treatment, and the court below ought to have considered these aspects and ought to have granted compensation. He submits that the documents which are filed by the claimant were not disputed by the respondent. As such, basing on the said documents, court below ought to have granted the compensation. The court below, considering the circumstances and the manner in which considering the evidence on record, and the crucial dates, that is the date of accident, the date of complaint, the date of MLC, and the suspicious circumstance under which the entire case rests on, has dismissed the petition. This court finds no reason to interfere with the said finding. Accordingly, appeal is dismissed.
Chopping.
Bill number 16, O Mahesh.
I appear the respondent claimants.
Yes,
But my appeal on question of Lord, the false claim has been foisted against the.
there are two appeals, both by the claimant and insurance company.
Placement. Claimant accepted enhancement.
Yes. Yes,
But date of accident is 12/9/2009,
yes,
7:30 AM on Hosur Road.
yes,
It is the case of the Lord injured. Anwar Pasha, aged about 45 years. Said to be that he was a pillion rider on motorcycle KA05ED 7248, and the rider of which was his brother Gafoor.
yes,
The owner of it is stated, my lord, that the tractor trailer insured with the appellant came from the opposite direction and dashed against the motorcycle.
yes,
FIR, my lord, is by the brother of the injured, Exhibit B1,
yes,
on 17/9/2009 at 2:30 PM. Though the accident was on 12/9/2009 at 7:30 AM.
yes,
5 days delay in lodging the complaint. You must kindly observe that complaint, my lord, was registered on 17/9/2009 at 2:30 PM. Immediately, my lord, the concoction started. Exhibit P3, the Mahazar, said to have been drawn on 17/9/2009 in presence of the complainant between 3:30 to 4 PM.
yes,
IMA report, my lord, is stated to be on 19/9/2009 in Manekal police station.
yes,
The IMA report, my lord, indicate that no visible damages to the tractor trailer. And so far as the motorcycle is concerned, right side petrol tank damaged, front mudguard and right foot rest damaged. The defense of the, my lord, the insurance company is that the injured himself was riding the motorcycle. And
Yes.
it was the case of the self-fall. There was no contact between the two vehicles alleged to have been involved in the accident. First respondent is the owner of the tractor trailer. He remained ex parte, being a compromised respondent to favor the claimant injured. The defense taken by the insurance company was that tractor trailer is not involved, and even otherwise the driver of the tractor trailer had no valid driving license.
yes,
Then, my lord, exhibit P5 is the wound certificate issued by St. Mark's Hospital, dated 15/10/2009, which says first seen on 30/9/2009 at 1:40 p.m. He himself, my lord, went to the hospital, not accompanied by anyone. And the history is only RTA. No vehicle number, my lord, is forthcoming. Yeah. Now, my lord, I invite your lordship attention to the defense taken and called out by the tribunal, my lord, at ink page 11,
Yeah,
para 4,
yeah,
second para. In the statement of objection, the respondent number 2.
no,
And-
that I have seen. Come to the finding, that I have seen. Your objections I have seen. Come to the finding,
Then issues may kindly be looked into, my lord.
yes,
The contention raised by the insurance company, only if the formal 3 issues are framed. No issue as to the validity of, my lord, the driving license, and also the defense of self-fall of the injured.
yeah,
Then, my lord, I'll take your lordship through the, my lord, the reasoning of the, my lord, tribunal, which starts, my lord, at para 12,
yeah,
in page 14. Exhibit P1, copy of the FIR and complaint shows that one Gafar, son of Pyarusab, has lodged the complaint that the brother of the, my lord, the injured, to the concerned police on 17/9/2009 at 1:30 p.m. pertaining to the said accident. That is in respect of 12/9/2009 accident. Gafar is none other than the younger brother of the present petitioner and also the alleged rider of the said motorcycle at the time of accident. In the complaint, it has been mentioned that the above said date, time and place when he was riding the said motorcycle along with the pillion rider petitioner from Hosur towards Anekal. At that time, the driver of the tractor and trailer bearing registration number so and so drove the same in a rash and negligent manner from opposite direction. That you will kindly note. And dashed against the said motorcycle, and in the said accident, his brother Anwar Pasha fell down and sustained injuries on his body. Lord, here, pausing for a moment, my lord, I would like to invite your lordship attention to, if, my lord, the brother of the injured was riding the motorcycle and the tractor has come from opposite direction back, the first person to be injured would be the, my lord, the rider. Our contention that the injured petitioner himself was riding and he has been, my lord, shown as a pillion rider. And in the light of, my lord, the damage caused to the motorcycle, that is exhibit P4, my lord, IME report, shows the damage to the right side petrol tank and footrest. So this probable preponderance and probability that the injured himself was riding the motorcycle. Then, my lord, to continue, a motorcycle, and in the said accident, his brother Anwar Pasha fell down and sustained injuries on his body, and he was shifted to government hospital on Eka. That you will have kindly similar. 3 hospitals he have visited, and thereafter he was referred to Victoria Hospital, Bangalore, and then referred to St. Mark's Hospital, Bangalore for higher treatment. And after providing the treatment in the said hospital as an indoor patient, he came later and filed complaint against the driver of the said tractor trailer. Malad, here he says, Malad, that he was with the injured brother claimant. Now, Malad, I invite your lordship attention to, Malad, the exhibit B5 wound certificate, which shows,
Yes.
Malad,
yes, yes,
He appeared self on his own, not accompanied by anyone. And history given, my lord, is only RTA. No number of the vehicle, no motorcycle, no tractor, my lord, has been mentioned. You have to kindly see, he was first taken to Anekal Hospital, then Victoria, then goes to St. Mark Hospital. No documents of Malad earlier two hospitals are produced. And what was the history given, Malad, has been kept away from the shifted to government hospital Anekal, and thereafter he was referred to Victoria Hospital, Bangalore, and then he was referred to St. Mark Hospital, Bangalore for higher treatment, so on. So this is the averment of the complaint. Exhibit P3, the spot Mahazar, shows that the concerned police have drawn the said Mahazar on 17/9/2009, immediately after the Malad complaint was lodged after 5 days. And the place of accident was shown by the complainant, and the police have drawn the said Mahazar in the presence of Panchas, and at the time of both above, the said vehicles were lying on the spot.
This is important.
Yeah, we'll come to that. 5 days, my lord. The vehicles were lying on the road, my lord, it's an impossibility. And the said motorcycle was damaged. Exhibit P4, copy of the IME report shows that the concerned IME report inspector has inspected both the said vehicle on 19/9. Then you have to kindly see the complaint, my lord, is on 17/9, and these vehicles, my lord, were examined in the police station 7 days after the alleged accident. Then, my lord, further reading. Exhibit P5, copy of the wound certificate shows that the present petitioner injured has taken treatment at St. Martha's Hospital, Bangalore at 1:40 p.m. for the injuries sustained by him, and the cause of the injuries is shown due to road traffic accident at Anekal and Hosur Road on 12/9/2009 at 6 p.m. First, my lord, the accident is said to be, my lord, on 12/9/2009 at 7:30 a.m. Exhibit P2 is the copy of the charge sheet, so on so on so. This is the, my lord, the evidence. Then coming to, my lord, the para 14. In order to rebut the above evidence of the petitioner side, the respondent number 2 has got examined its authorized person by name Muralidhar N, assistant manager of the claims as RW1. In the examination in chief evidence, RW1 has stated that the insured vehicle was not at all involved in the alleged accident, and they have appointed the investigator to collect the document and verify about genuineness of the claim. The insured, that is the respondent number 1, has intimated that insured vehicle was not at all involved in the alleged accident, and his friend Mr. Janardhan had taken the copies of the vehicle document and implicated his vehicle in the alleged accident. In view of the same, it is prayed that to dismiss the petition as against the respondent number 2. During the course of argument, the learned counsel for the respondent number 2 has argued that the owner of the said tractor trailer, respondent number 1, has stated before the investigator appointed by the respondent number 2 insurance company to the effect that it is said accident is a tractor and trailer was not at all involved in the said accident, and he had given the document of the vehicle to his friend, namely driver Janardhan, and and there is no relevant or any connection with his vehicle to the said complaint, and the same has been stated by him as per Exhibit R2. His statement will not recorded by the investigator, marked as Exhibit R2. Hence, the claim petition is liable to be dismissed. As against this, the learned counsel for the petitioner has argued that the said Exhibit R2 alleged statement said to have been stated by the owner of the said tractor trailer is actually not at all stated by the respondent number one, owner of the said tractor trailer. But the said alleged statement has been created by the insurance company in order to escape from its liability to pay the compensation, and therefore the said document cannot be taken into consideration. Bearing in the mind the above respective contention of the parties with respect to the contents of Exhibit R2 is concerned, if we peruse the contents of Exhibit R2 document, it is seen that as per this document, the owner of the said tractor trailer present, respondent number one, said to have given the alleged statement, but this document does not reveal as to before whom the said the statement was given by the owner of the said tractor trailer, and whether the said the statement was actually written by the owner of the said tractor and trailer, or somebody has written the said statement as per his say. Such wording in presence of Exhibit R2. Moreover, the said Exhibit R2 alleged statement shows that the second page is left blank, but the signature of Narayana Swamy, alleged signature of the owner of the tractor and trailer, is present, in which there is no writing in the present or before the said signature. The respondent number two has not clarified as to why such alleged signature is present in a second page, even though the second page is left blank. This itself creates a doubt also. Well, this forgets about the malad that the papers are given to him. The insured malad signed on all the papers. Even the blank paper has also been signed. This insurance malad, the signature is not disputed. On that basis, malad, the exhibit malad, the R2 has been disbelieved. Then coming to malad, issue number 2.
Continue. Just
I'll continue. Therefore, mere production and marking of Exhibit R2 document does not dispense the proof. Under such circumstances, no value can be attached to the contents of Exhibit R2 statement, and thereby content stated in that statement not at all actually stated by respondent number one to the effect that the tractor was. Well, in respect of this, my lord, the investigator has been examined. And my lord, so that is the this thing, my lord. Then my lord, coming to issue.
It appears Lordship, it appears that on 23. Skipping that one.
Issue number 2, para 17. In the oral evidence of petitioner PW1, as stated with regard to the injury sustained by him in the said accident, Exhibit P5, that's the wound certificate, my lord. Copy of the wound certificate shows that the petitioner has sustained 2 simple injuries and 2 grievous injuries, and the said grievous injuries are segmental fracture of lower 1/3 of right femur, fracture of right leg, tibia and fibula. Exhibit P6 is the discharge summary of St. Martha's Hospital, Bangalore, who also shows the same. The said document also shows that an operation was done so and so. When the doctor has been examined, the doctor says about that. My first contention will be that
Yes,
the injured himself, my lord, was riding the motorcycle, had a cell phone.
yes,
The contention that, my lord, the tractor trailer came from the opposite direction and dashed against the motorcycle. If were to be, my lord, true, then the rider, his brother, should have been the first person to get injured. Because the right tank of my lord, motorcycle has been damaged. That means, my lord, that the petitioner himself was riding the motorcycle and had an accident. Therefore, my lord, he was shifted as a pillion rider to make a claim. And evidence of, my lord, this statement of, my lord, the owner recorded by the investigator of the insurance company, my lord, disclosure that his vehicle was not involved, but documents were taken by the driver, Janarthan.
Yes.
All this, my lord, indicate that this vehicle has been implicated, my lord, with the intention of making a unlawful claim against the, my lord, the injured. Therefore, my lord, my respectful submission, your then not the other defense taken was that the driver of the alleged tractor trailer had no valid driving license. In respect of that, my lord, RW2, my lord, Anand Kumar was examined, who is the officer of the, my lord, RTO Bangalore. He says that he was not having a license authorizing to drive tractor trailer.
Then what is he having?
He was having, my lord, exhibit R4 is the driving license, motorcycle with gear.
Motorcycle with
With
gear.
gear, without gear, with gear. It was issued, my lord, on 10/11/2004 to 9/11/24. The distinction, my lord, which I want to make is, if it is a other than a transport vehicle, my lord, the license will be for the year 20 years. If it is a transport vehicle, it will be only for 3 years, which has to be renewed on medical examination that he is capable of driving. Therefore, it will be renewed. Therefore, my lord, this shows, my lord, on this ground that you are not having the valid driving license to drive a transport vehicle like tractor trailer. So on these grounds, my lord, appeal has been filed.
Light motor vehicle and having a light motor vehicle to drive.
ಸ್ವಲ್ಪ ಇದೆ ನೀವು ಹೇಳುವಂತ್ರಿ. My lord, Anekal hospital report not produced. Victoria Hospital, my lord, is not produced. Then St. Martha's, my lord, has been produced on 59, says self. He himself has presented, he was not accompanied by his brother, who said that there was a delay of 5 days in filing the FIR because he was attending on him. So all this, my lord, creates the doubt, my lord, how the claim has been created against him, my lord, the insured tractor.
Yes.
I should kindly see that immediately he had taken first aid treatment at Anekal Hospital, and again at Victoria
Not on the
Hospital.
liability, on the enhancement.
Announcement, my lord, he suffered. He was treated inpatient for about 54 days
Yes.
and underwent multiple surgeries. Tribunal not granted loss of earning capacity, and the only ground that doctor was examined as was not treated him. And let's kindly see the para 40, para 17, my lord, onwards.
Yes, I've seen that.
So he was totally inpatient for 54 days
Yes.
and underwent several surgeries. Doctor assessed his disability whole body at 22%, 25%. And the only ground that the doctor has been, all the documents have been summoned and marked from St. Martha's Hospital.
With your lordship permission, my lord, I would like to make one. The doctor examined is one Ramachandra of Boring Hospital, not of St. Martha's.
That's what.
One minute, let me finish. This Dr. Ramachandra, my lord, is a stock witness for all injury cases.
That all out of record.
Yes, I can prove that. There are records to show the judgments of the Honorable High Court. Apart from that, my lord, why the treated doctor is not of St. Martha's not examined?
He was also examined. Shishidhar.
One minute, either of you make the submission. He wants to conclude. Let him conclude.
Please,
Yes, the counsel for the insurance company.
please, ma'am.
Yes. Mr. Mahesh.
Yes, my lord. Therefore, my lord, I just wanted to, my lord, at this point, my lord, to point out to your lordship, Dr. Ramachandra, my lord, is not a treated doctor.
Yes.
Admittedly, my lord, he was gone to Anikal Hospital, Victoria Hospital, and St. Martha's. He was never treated in Boring Hospital. No doctor from St. Martha's or Anikal or Victoria Hospital has been examined. Only the doctor Ramachandra, who is in Boring Hospital, is not a treated doctor, has been examined.
That's why the court below is disbelieved and not granted the disability, whatever he was pleading.
But why I did not make mention is, my lord, my thirst was that the vehicle has been implicated. Then, my lord, if it comes to, my lord, quantum and
Yes.
booking of this, my lord, then exhibit P5, my lord, issued by St. Mark's Hospital, says self, he appeared himself and said RTA. Doesn't mention, my lord, about any type of vehicle or number of vehicle. Exhibit P5 may kindly be looked into at this stage. Issued on 15/10/2009.
I learned to already argued that point again.
Listen, I want to reinforce requesting the court to look into that exhibit P5 at this juncture.
Yes.
Yes. Therefore, my lord, the evidence of, my lord, this doctor PW3 Ramachandra, who is not a treated doctor, does not hold any water.
Yes.
Like
Yes.
PW2, Dr. Shashikant from St. Martha Hospital was also examined and he has produced all the documents, but he has not assessed disability. So, Ramchandra was examined, assessed disability. It is, in fact, one of the judgment of this honorable court is held that it's always proper to examine the doctor who has not treated treated the petition. Since the treated doctor is influenced by his treatment, so he will give disability on the left side. So it is the doctor who has not treated, he has to be examined to get the proper assessment of disability. That's what this honorable court said, one of the judgments.
What is the judgment?
My lord, I can pass. Right now, I don't have. I'll pass on. And relying on the famous book that I'll punish the judgment. Justice judgment. So regarding a support underwent several surgeries, Lordship, can you see that? That's what there cannot be a major surgeries and segmental fracture of right femur. Lordship, see the nature of injury he has suffered. Totally.
Now there are on compensation two aspects. One is about disability, one is about the injuries.
Injury.
And the amounts you have spent on treatment.
Please.
First question on the question of disability, the court, as you have not examined the doctor who has treated you, court has disbelieved the same and has not considered the disability.
Please.
According to you, as per the judgment of this court, a doctor who has not even treated, his evidence is more reliable.
More reliable because he is not influenced by his treatment. The doctor who has treated him, he gives lesser disability.
We will see the judgment.
I'll pass on the judgment, my lord. Right now, I don't have.
If you can have it tomorrow, I'll post this matter for judgment tomorrow.
Please, ma'am. Kindly post judgment. I will give it tomorrow.
Tomorrow for judgment.
Further hearing.
For further hearing.
Please.
Tomorrow for further hearing, heard counsel for the appellant and the counsel for the claimant in part.
Please.
Narayan Shetty.
Okay. Amigo for this. What is the counsel for appellant? So it's a claimant's appeal. So let's see what it is. Case of injuries. How much was claimed? How much was granted? One lakh? Let us, come to the issue. Para 17. You are for the appellant. For the insurance company. Yes.
There's also taken treatment in the hospital. The discharge is the all treatment and also taken treatment as outpatient. The registrar has spent 50,000 medical activity, 8,000 food and I spent 10,000 financial. If we do about 2,000, but they can't have to do more the and factor 7.3 winner operation more the case finger and left leg. Before the official suspend related to the treatment has taken the treatment in the ground and the hospital and executive visa certificate period 2 is extra. In the hospital, in the treatment percent legal body. On the opponent have according to the discussions market activities at 6 days, the opponent has not significantly included the lease. The assets were particular more for spent 18,000 income, 18,000 to the. He has taken 18. He was not very no. The apart from the activity not attend to work for not only any more documents the extended agency as our government
bit detail.
First of all, the opponent process on the derivative, then derivative specific he has done it difficulty in any let us on this side of the money. What is money? Question that whether if it is stated that running about the 36 here. I mean, here to one of it. Yeah, we get that. Bigger is like. Criminal is not provided. The compensation taking the 35% the rate has been paid.
One lakh 68,791. 1,68,791. What was granted was 1,27,000. Really? You will appeal by the agree with brother. Number the claimant. Please move on passing. NBC number 88 of 2006. Dated 6 December 2013. There was no representation on behalf of the appellant several times and even on 31/7/2023. Then this matter is posted for dismissal today. Today also there is no representation on behalf of the appellant. When counsel for the respondent insurance company is present. The claim petition is filed seeking compensation of an amount of rupees 5,73,000 and the tribunal has awarded an amount of rupees 1,27,790. The case of the claimant is that on 6/5/2012 at about 2 a.m., the petitioner was traveling in the auto rickshaw when from Osanagari towards Chittor, when auto reached near Ampar Junction, driver of the auto drove the same in a rash and negligent manner, crashed to the electric pole. Due to the said impact, the petitioner fell down and sustained grievous injuries. After the accident, he was shifted to Durga Hospital, Aladi, and he was taken inpatient treatment from 6/5/2012 to 15/5/2012. He was discharged. The advised to take bed rest and follow-up treatment. He has spent 50,000 towards medical expenses, 8,000 for food and nourishment, 10,000 for attendance charges. According to the petitioner, He is working as a driver and earning rupees 7,500 per month. Due to the accidental injuries, he has suffered loss of income and future prospects. It is also the case of the claimant that because of the injuries sustained by him, he has suffered a disability. In support of the same, he has examined PW2, the doctor. As per the evidence of the doctor, the claimant has suffered disability at 10% to the whole body. In support of the same, he has produced exhibit P10. In the evidence, PW2 in the cross-examination has stated that he is having difficulty in, the claimant is having difficulty in bending, turning, and doing strenuous activities, and fracture is malunited. The court observed that while considering the impact of the said injury on his future prospects, court has observed that the claimant has sustained fracture of ribs. He has not undergone operation. He has not produced, the doctor has not produced guidelines or clinical notes for arriving at 10% of the disability. Mere production of disability certificate is not sufficient to prove the loss of earning. As such, the court below was not inclined to consider the disability by applying the multiplier and granted an amount of 35,000 under the head disability. Further, towards pain and suffering 35,000, medical expenses 25,790, loss of earning during the laid up period, considering the income at 6,000, as no evidence is produced, 12,000 was granted for a period of 2 months, and loss of immunity 20,000. Loss of immunities was not added. Then it will become 1,88,000. 1,88,000 it will become. Huh? No, that was not added. In the amount that towards loss of immunities 20,000. The court below has rightly not considered the evidence of the doctor PW2, who has issued a certificate and stated that he has suffered the disability at 10%. But he has not given on what the particulars, basing on what he has come to the conclusion that it is 10% disability. But the fact remains is there is a malunited fracture. The court below has granted 35,000 under the head disability. This court is inclined to grant 50,000. Towards pain and suffering, an amount of rupees 35,000 was granted. As per the evidence, he has sustained 1 grievous injury and 2 simple injuries. For that, under the head of pain and suffering, he is entitled for 60,000. Towards the medical bills, the court below has granted 19,791. That is a reasonable amount. But towards extra nourishment, transport, and attendant charges, only an amount of rupees 6,000 was granted, which is a very meager amount. This court is inclined to grant 15,000. Towards loss of income, though according to the claimant is earning 7,500, but the court has considered 6,000 as per the notional income fixed by the Legal Services Authority. This accident has happened in the year 2001. At 7,000 for 2 months, he is entitled to 14,000. And towards the loss of immunities, court has granted 20,000. This court is not inclined to interfere. Towards legal expenses, 10,000. Altogether, the claimant is entitled at an amount of rupees 1,88,791. Accordingly, appeal is allowed, enhancing the compensation from 1,27,792.
Claim number 18, Chandrasekhar DM.
The litigants consider this split. Let's pause it. End of. Item 18.
Claim number 18, Chandrasekhar DM.
What about this matter? This is the claim. Let us see that issue.
The filed an application of 11/14. That application has been allowed and directed the petitioner to produce the policy particulars before.
No, about the policy, where is that finding?
One sign, that's one of the judgment.
Yes. You don't have. Give him the papers. Please.
And what is also the much not really
No, when they prepared an appeal, they'll question two, not one. Where is that negligent, on negligence, where is the finding? This appeal filed for the claimant. The court agrees with the amount passed on condition number 9034 of 2010. The claim petition is filed seeking compensation of an amount of rupees 7,92,000 for the injuries sustained by the claimant in the accident. The tribunal has held that there is contributory negligence on the part of the claimant and fixed the same 25% on the claimant and 75% on the owner of the vehicle. The court below has exonerated the insurance company from the liability. And granted compensation of 30,000 and apportioned the same and granted that apportioning as there is contributory negligence. 40%, not 60-40. I said 25-70, 40-60. And granted an amount of rupees 18,000 as compensation. This matter, there is no representation for the claimant. The same is posted for dismissal. And today also, there is no representation on behalf of the appellant. And this is an appeal of 2014. The court is proposing to hear the appeal and will learn counsel with the respondent present and advance his arguments. In this case, according to the claimant, while he was on 15/8/2010, while he was standing on the footpath in order to cross the road, all of a sudden, a bus belonging to the first respondent came in a high speed in a in a rash and negligent manner and dashed against the petitioner and caused the accident. The bus ran over both feet of the petitioner. The petitioner has sustained fracture and crush injury, and he has spent more than 60,000 towards medical expenses. According to him, he is earning 6,000 per month. The court below, on issue number 1, held that on going to sketch, that is exhibit P3, it clearly is evident that the accident caused on the left side of the road and there are no zebra cross or other signals for crossing the road. Therefore, the version of PW1 that the bus dashed against him while he was standing on the footpath is not reliable and it is not trustworthy. Court further held that while the petitioner was trying to cross the road, by the same time the driver of the bus has to observe the person who are likely to enter in the road, as the place of accident is a public place and junction. Hence, held that there is contributory negligence on the part of the accused, which is quantified at 40% and 60%. Then coming to the injury, according to the claimant, he has spent 60,000. The court held that he is entitled for the benefits under the ESI Act. Hence, he is not entitled for any medical expenses. And towards a crush injury, and because of the crush injury, he has not sustained any disability, nor any evidence is produced in support of the same. Hence, granted a compensation of rupees 30,000. And as per the apportionment, granted 18,000. This court has perused the entire award and the material on record put below, both on the contributory negligence second, as far as the insurance company is concerned, the court has exonerated the insurance company as no document was produced to show that the said vehicle is insured by the insurance company. As such, the liability is fixed on the owner of the vehicle. In this case, neither the petitioner has not produced any particulars that is insured with the respondent insurance company, nor the particulars of the policy. Hence, the court has come to the conclusion that it is not insured with the respondent number 2. There is no, even on that, the court below has rightly dealt with the said issue. Since the court finds no reason to interfere accordingly.
I am for the second respondent, my lord.
It will
Second
hear it
respondent,
tomorrow.
PMTC.
As to list will come tomorrow.
Mahesh.
Sir, it will be heard tomorrow, sir. The rest of
please.
it will be heard tomorrow.
ಇಲ್ಲ ಅದು ಹಂಗೆ ಅರ್ಜೆಂಟ್ ಆಯ್ತು.
ಏನು ವಿಜಯ್ ಕುಮಾರ್?
ನಾಳೆಗೆ
ನಾಳೆಗಾ? ಸರಿ.
ಹೌದೌದು.
ಎಲ್ಲ ಫಸ್ಟ್ ರೌಂಡ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಇಲ್ಲ ಅಂದ್ರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
Sir, yes, sir.
ಸೀರಿಯಲ್ ನಂಬರ್ 7 ಏನಾಯ್ತು ನೋಡಿ. Serial number 7.
Notice to R1 and R2, serial number 7.
Notice to R1 and R2 2016 ಮ್ಯಾಟರ್ ಇದು. ಅಲ್ಲಿ ಇವ್ರದ್ದು ಅಡ್ವೊಕೇಟ್ ಫೋನ್ ನಂಬರ್ ಏನಿದೆ ನೋಡಿ ಮೇಡಮ್.
M. Anil Kumar, sir. Sir, file ಇಲ್ಲ ಎಲ್ಲ ಚೇಂಬರ್ ಅಲ್ಲಿ.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.